Because I'm supposed to be recording. All right, hello everyone. Thanks for joining us for our webinar on how to interview applicants for employment without getting into hot water. Our presenter this afternoon is Mark Tilkens, who's the managing shareholder at Jackson Lewis in Madison and Milwaukee. He's a very seasoned labor and employment attorney, and we're very grateful to have him here today. So just a couple housekeeping items before we get going here. For those of you who are joining us on the phone, if you want to ask a question at any point during the webinar, feel free to do that. You can submit written questions by clicking on the chat feature, and we'll be monitoring the chat feature if you want to type in a question, and then one of our organizers will ask your question to Mark, and Mark can answer your question throughout the webinar. So without further ado, I'm going to... That was unpleasant. Sorry about that. Not sure what happened there. But without further ado, I'm going to hand it over to Mark Tilkens. Thanks for being here, Mark.
Thank you, Lori. Good to talk with everyone. I appreciate the chance to speak with the group today, and I very much want this to be speaking with folks, not to folks. The topic we're covering today is getting off on the right foot, some best practices for purposes of handling applications and interviews in the hiring process. And these are steps that will be generally applicable to any part of the hiring process, whether it's assessment center or further steps for callback interviews. And the content that we're going to cover today is everything from the application through a variety of different steps in the interviewing process. And while we'll cover some legal principles, for the most part, today's content will be very practical. So we'll start with some slides that cover applications and then go right into some do's and don'ts on interviewing. And the goal here is that the slide deck, the handout, the materials here will very much be something that folks can refer back to over the course of time. And I put in enough content from a detail standpoint that you can actually take from a copy and paste standpoint, take some of the materials and build your own list of interviewing questions, or at least the skeleton of some interviewing questions for you to use as a template to begin this process, particularly if interviewing or reviewing applications is not part of your job that you've done before and this is new to you. This was designed to be very user-friendly from a beginner or a refresher for folks who have done this before. My background is I represent only employers. Our firm is exclusively management side labor and employment representation. We have 57 offices throughout the country. The 2 Wisconsin offices are offices that I manage, and we have a fairly diverse group of lawyers from a practitioner standpoint. In other words, we handle labor issues and employment issues. So the content here that we're covering today is something that I deal with and assist employers with on a daily basis. And the goal is for us to take a very complex area of law and make it as practical as possible so that you don't end up stuck in a place where you can't understand the conflicting laws that are very helpful legislators have done such a wonderful job of building a complex morass that is a set of bear traps for everyone to step in. So it's my pleasure to be here, and I very much enjoy the training component of my work. It's much better than dealing with opposing counsel, judges, or unions. And so thanks, and with that, we'll get going. So the very first thing we're going to talk about is applications for employment. And so think about the application process and start with the application that you've used over the course of time, and look at that application with a fresh set of eyes and ask yourself, is everything, every inquiry on that application something that you really need? Or is it a boilerplate application that someone many years ago started using and it really ought to be looked at again? All the things that we do as employers, for the most part, are things that we end up just doing because we've always done them. And the problem with that is we rarely stop and take a moment and ask ourselves if that now is the best way to do it. And so the starting point with your application is see what you've been using and then ask yourself if everything on there is something that you need. Think about adding to it if it isn't already there. Think about adding a statement of non-discrimination, something that is a self-serving statement that you would put in there for purposes of putting all applicants on notice that you take this seriously and that you're interested in information that relates to their skills for the job, their experience, their education, their background for the job, and not the protected categories that we're going to be talking about today. Those protected categories are ones that we've heard about before, but they deserve mention. I've got a slide on those later that you can use for a folder to refresh your memory before you begin in the application process. Think about it, adding language that will describe your willingness to accommodate disabled applicants. That does not mean that you will have to provide a job that a disabled applicant couldn't perform with a reasonable accommodation. That is an entire body of law that requires a number of steps to perform it correctly and lawfully. But think about putting in language that will encourage people with disabilities to feel like they have a shot at the job. That is the law, after all. And even if you don't hire the person, you may end up avoiding a fight or a piece of litigation if it is if that applicant feels as though they got a fair shot at the job. And then think about language in there that disqualifies dishonest applicants. It does not matter whether an applicant falls into the protected category of race, age, gender, disability, religion, down through the list of all the protected categories. If the person is not honest with us, it does not matter if they fit in every single protected category. We should, and we should always follow this, we should police the applicant process and our pool of employees for those people who lie to us. If they're willing to lie on the application and the interviewing process, that is what I used to call, when I was in law enforcement, a clue as to what's going to come down the road once you're trying to employ them. And so think about putting that in there, that any information that's misleading, false, or a misstatement of fact that they drop in there, like lying about where they've worked, we will not consider their application further and just disqualify them from the process. Now, there's a catch in there. You cannot, like any other rule, you cannot insert a rule like an honesty rule and then only apply it to certain individuals at your convenience, because what you've done then is selectively enforce that rule and open it yourself up to a discrimination claim. So if the first time you attempt to enforce a rule like honesty on an application happens to be an individual who's over the age of 40 and falls in a protected class, perhaps is a disabled individual, and you've overlooked 5 lies before that for white males under the age of 40, guess what problem you've created for yourself? And you are to blame for it because you've constructed a rule and then not followed it uniformly. So be thinking about that from an application standpoint. And folks, feel free to interrupt at any time with questions, comments, etc. So things that you should avoid asking, things in that application that you should not be seeking, information that's not useful for evaluating skills. Maiden name, relationship of their emergency contact person. Does it really matter if the emergency contact person is a spouse or a brother or a friend? Bottom line is you need an emergency contact person, or you may need an emergency contact person, and you're looking for a name. You're not looking for the relationship. That doesn't matter. That's just a bear trap waiting for you.
Mark, can I interrupt you with a question
Yes.
on maiden name? So what if I'm, interested in verifying the educational history of a married woman who completed her undergraduate degree when she was unmarried? I mean, how do I go about, dealing with that without getting myself into trouble?
Yeah, you should be able to ask for, in the educational history portion, ask for educational history, and then if there's any alternate names that the person would have registered, ask it in that section so you've connected it up with the area of inquiry that's lawful. If you've got a section of the application that just highlights as independent in the beginning of it next to name, maiden name, the signal that we're sending to applicants is, I'm interested in knowing whether the folks are married or not. And in Wisconsin, marital status is a protected category by itself, and so we may not discriminate against people who are married or unmarried based upon the status. Now, there's a nuance here. Who they're married to is not part of the discrimination statute. So if you terminate an employee and you don't want to hire their spouse because they are married to that particular terminated employee who stole from us, for example, this would be an example, it is not marital status discrimination to disqualify the person's spouse because of who they're married to. It's the status of being married. So we cannot have a rule that favors young unmarried people because we believe that we can work them into the evening because they're less likely to have family obligations. That's the basis, the policy purpose behind this. So I would take the issue of a person's former name in education, and I would attach that in the education section and tie it to what we're seeking, which is we want to know if a person has a certain qualification from an educational standpoint.
Okay, thanks. That's helpful.
Okay, on this slide, we're also looking at age, date of birth, and place of birth. We want to avoid asking a person's age. It's not helpful to us to know their age, and all it is really leading with our chin. You're likely going to be able to tell. If we're really interested in trying to assess people's age, this kind of thing is going to come out based upon a number of other pieces of data. And so asking about age is really just asking for trouble. We don't need to know how old someone is. You're going to figure that out through other questions like, and tell me your educational experience. How long have you been performing this type of work? Well, I just ask them about their work, and what I'm probably going to get is a little bit of a life story around how did you enter this area of work? What did you do before that? I'm going to figure out in the course of my interview really what this person is like. And I get a pretty good sense of how old they are if I happen to care about that. But we should not be thinking about age as a factor in making any decisions because the law says it's illegal. Existence and identification of children, marital status. We don't want to be asking about that. Again, just leading with our chin there. Availability for weekend work. We are not interested in disqualifying people who may not be available for weekend work. Now, does this mean that we should not ever consider putting people, what if the work that we're seeking to fill is only weekend work? Well, the way we can describe that is the job that we're seeking to fill is a job that involves a shift on Saturday morning until Saturday evening, and it goes through Sunday and then into Monday. Are you interested in this job? Which is much different than asking this question. And workers' compensation history. We should not be asking about a person's workers' comp history because the statute prohibits us from isolating people on that basis. All right, some do's and don'ts in the interviewing process. So if we transition from applications to interviewing, this is a very critical point in the process. It's one of the best points in the process, far better than applications for figuring out what makes people tick. And there's a whole lot you can learn beyond what someone will write on a piece of paper that will define whether or not you think the person's a good fit or will be a good worker. And how you get that information is a very important thing. All of the information you want to know about a person that is prohibited by the content we're covering today is really something you can get just by having a good conversation with an individual. And really this exercise in interviewing lawfully is really just one that's focusing on avoiding some of the known bad questions that get employers into trouble on a day-to-day basis still in 2016. And so that's where we're focused on with this next couple slides here. So use this very helpful process and think about the people conducting your interviews. You want people who can be controlled, you want people who can be trained, and you want a small group of people who do this. This is not the time to pick 10 people who know the job very well and then just put them in a room and expect that they're going to know how to do this very well. It's a different job and it requires someone to know what they're doing. Prepare them. Think about the job that you're seeking to fill, and then ask the people who are going to interview individuals, ask them to prepare a list of functions that the employees will have to perform. Have them be skilled individuals at extracting information and evaluating people. This is even nonverbal communication, slumping in the chair, frustrated sighs. These are things that can't be captured on a piece of paper, but these are things that your interviewers should be noting. Those are not related to any protected category, but they do tell us about a person's eagerness for the particular job. And you should know that if you can detect it early on, because they're going to express that same kind of behavior in the workplace later when it's much harder to get rid of them.
Hey Mark, can we go back for a second to your previous slide about things to avoid asking on the application?
Yeah.
I don't see any reference to race or religion on here. Can I ask about those on the application or during the interview?
You shouldn't be asking for race or religion. I've covered those in a different area of the slide deck, but we really shouldn't be seeking information on race or religion or sexual orientation, a person's previous income sources in certain jurisdictions is unlawful. any of the categories that are prohibited by law we should not be putting on the application form.
Okay.
Good question.
Just wanted to clarify that. Okay.
Okay, so if we jump ahead to the slide that starts with interviewing suggestions, you want to ask for examples. So think about using the following words that are on this slide in your interview questions. Describe for me, Lori, how you performed that previous job that you just told me about. Or, oh, Lori, how was it that you were successful in that job and ended up promoted through the course of working for that employer? Another one, explain for me what you found to be an area that you were the strongest in. Explain for me the areas you struggled the most. And don't tell me there were no areas you struggled in, because we all have areas we're better at, worse at. Feel free to be open with the candidate and direct with the applicant during the interview process about things that are realities for every employee. None of us are perfect in every way, and it's okay to be that direct. Or next word, let's discuss that. Would you please just, for the group that's interviewing you, would you please just discuss what you found to be the most difficult part of working with supervisors in the past? Draw out that applicant by asking open-ended questions like this. The words what and why are two other ways to do it. This continues in the same vein here. This is information producing questions. How did you expand your responsibilities? These are all questions on this slide that you can draw right out of the slide deck and use in your own interview questions. You can build off them too. Discuss some of the problems you encounter. What areas would you be able to impact immediately? What kind of supervisor would you like to work for? Tell me why you left. Tell me what your references are likely to say about you. What would your previous managers say about you? Where do you think you need training? What are you not good at? These are fairly direct questions. And if a person says to you, well, there's nothing that I need training on. I am perfect in every way, and there's nothing that I need to improve on. You've picked up another one of those things we call clues, because there is no such applicant in the world. Or please hire that perfect applicant, because it'll be the first one that we've ever run across in our lives. All right, some legal rules. These are some do's, and then in the next slide we're going to follow up with some don'ts, and then we're going to get into those actual protected categories. So from a standpoint of do's, questions that are related to the job. This is where a few slides ago I told you, think about having someone actually identify the things that the person does in the course of employment. What are the tasks that the person will be asked to perform? What are your best employees today perform, and why are they the best? Those are the things you're going to want to ask applicants about.
So here's a question. You know, a lot of the folks who are members of my association are going to be interviewing people for the first time that they want to bring on as apprentices in the steam fitting program, because we're going from a ranked list to a letter of introduction system, and they may want to ask about the applicant's ability to lift heavy weights, things like that, because there's a reasonable amount of lifting associated with that job. Is that something that an employer should be careful about asking about, because it may get into an area relating to disability?
So if the job includes bona fide occupational requirements that are lifting limitations or restrictions or minimum requirements like you're describing, Lori, we should be identifying those beforehand, because if we just leave this to chance, in other words, if we just allow an interviewer to make up on the fly vague notions of, well, you're going to have to lift a lot of heavy stuff, so we're looking for a couple of young, strong guys to get this job done, I'm going to accidentally step into multiple categories. And in that example, I just stepped into age, I stepped into gender, and I stepped into disability. So disability was the health part, age was young, and then I also said guys, so I tied in the fact that we would prefer men over women. But it is not unlawful to have minimum bona fide occupational requirements like lifting requirements or moving requirements. That does not mean, though, that a disabled individual is disqualified from the job if a reasonable accommodation should be provided under law. But for interviewing purposes, the way we should construct this is we should think about from a position, a vacant position standpoint, we should be thinking about what are the minimum qualifications that a person must be able to perform to do this job, and then define those things based upon the job before we're ever sitting in an interview room. So it's lifting X amount. It is being on your feet X hours per day. It's being able to drive a truck. It's being able to, and just complete that list. And then we have constructed a list based upon the job, not based upon some accidental notions that a person just vaguely describes in the interviewing process. Does that help?
Okay. And should those be documented before?
Yes.
Okay.
Yes.
And is it sufficient to just kind of write a memo to the file saying here's what the requirements are for the job, or do you somehow have to communicate that to the applicant in advance or at some point during the interview process?
So there's best practices, and then there's what do you have to do to see a stay out of jail. Best practices, the employer will want the minimum requirements for the job that are the bona fide occupational requirements in a job description that can be shared with applicants who are interested in the job, because then they know what they're in for, and hopefully then you end up with a pool of applicants who are actually interested in performing the job that you need performed. So from a resource standpoint, we're not interviewing people who have no interest in working hard. If we step away from best practices and we talk about, well, what do you have to do just to stay out of jail? If you document that in some fashion before the interviewing process, and it comes up as a surprise, you will have engaged in a lawful employment process because you're not making it up on the fly. And the reason that you'll want it documented is the plaintiff's bar or a judge or an agency that's looking at this is going to think of these allegations that are cooked up later, and they're going to ask themselves, well, what was it about the applicant in the interview process that caused the interviewer to ask this question or to put out there this requirement? Oh, it must have been because the person needed a cane to get in the building.
Sure. And
all at once, out of nowhere, poof, in the middle of air, comes this requirement of lifting, and you cooked that up on the fly, and you did it because you frankly weren't interested in dealing with someone who was rehabilitating from an injury. So if it's documented beforehand, we have proof that we can rely upon that. You didn't make it up. It actually is a bona fide occupational requirement. Now, a best case scenario is we would have that communicated in some fashion so that the whole world knows about it, and it's founded in fact, and it's based upon us closely evaluating our jobs and put it in the job description. But that's a best case scenario. We know that all employers can't accomplish that at every point, but that should be the goal that we're striving for.
Okay.
To have job descriptions that contain that.
So here's a follow-up question to that. I mean, we're again moving from this ranked list to a letter of introduction system. I mean, I'm guessing there are general descriptions of what a steamfitter does that exist out there in the universe that employers could draw from, but do you think it would be advisable for employers to, build upon that and develop their own specific job descriptions? Because I'm guessing the work of a steamfitter candidate could be different from employer to employer depending on what different jobs that employer has going. So
yeah, the goal should be to customize it based upon how you use employees. Now that doesn't mean that an employer is locked into those defined parameters for their entire career. So as the business changes, you get a different job, there's jobs bid out, and the requirements of the job change from a lifting standpoint or an hours on the feet standpoint. The employer is not locked in.
Okay.
But for purposes of that interview process, what we're looking at here is a snapshot in time, and we're evaluating whether or not the interview was conducted lawfully. And at that moment in time, what's the job that the person is seeking and that you're hiring them for, and can they perform the job? And so it's best to have the job description and or the document that's in the file reflect what that employer actually does, and not just an industry generic standard, because that industry generic standard might actually contain something that's more strict or more lenient than your particular circumstances. And if you rely upon that and you disqualify an applicant based upon that, you frankly just disqualified someone based upon a requirement that isn't necessary for your particular workplace, which is the only thing in the world that matters. So they should be tailored. And that's also the reason why employers should never feel like you need to use some industry boilerplate in this regard. Customize it. Make a top 10 list of things that the person must do to do your job well. Don't overthink it. Sit down, spend an hour on it, write it down, and as the job changes, rewrite it and move forward.
Okay, great. Thank you.
You bet. So we were on this slide that talked about do's and don'ts. And we were just talking about related to job, and we covered that in many regards, but aspects of the responsibilities and qualifications. What does it take to do this well? What else is it that we can, from a do standpoint, empower you to do? Well, ask about prior employment, training, education, and experience. All those things are divorced entirely from protected categories. It doesn't matter what age, race, disability, etc. We want to know what they've done. Tell me what you've done for employers before that you want to brag about. Lori, tell me all of the things that are worthy of bragging to me about that make me think you're better than the rest of the pack. That's as simple as that, and I'm very direct about it. I want her to talk about herself, and I want her to do that in a way that impresses me. If she can't do that at the interview phase, I'm probably not going to be impressed later at the actual work phase. Relationships with former supervisors. Tell me how you've engaged with your supervisors. Tell me what you've done that's been successful for supervisors. Tell me what you've done that's been a complete failure when it comes to supervisors. I'm interested in knowing how she answers that as much as I am what she answers it with. So the how is very important. I'm looking for people who can respond to information in a truthful fashion. I'm looking for people who've worked before with supervisors. If you've only been a lone wolf on the job and you're looking to now work on a team, that might tell me something about your ability to work with other people. And all these things are important. So employees, customers, and vendors as well. Let's move into some don'ts. And we have a number of examples that come later in the slides, but don'ts. Don't make promises on the terms and conditions of employment. This is just an interview stage. This is not an offer you're expressing it. So you're assessing candidates. Later, you will have an opportunity to make a job offer to the selected candidates. But right now, we're interested in assessing. And it's very important in an interview process to not blend those two, even if you're rushed. After you've interviewed applicants, even if they're all sitting out in a lobby area because you need to move quickly, sit back, reflect on the information, ask a colleague, hey, test me on this. This person came in with a cane. Did I do this lawfully? Did I step on a bear trap? You're surrounded by people when you perform the actual work that you do in your given trades, and you don't do those things alone. You have teams. So this is another area where you should think about this just like the primary work that you do. Test each other, ask each other. There's no such thing as asking each other too many questions about getting this right. Look out for age discrimination. So we're gonna step into some of these actual categories. Here's a question that's a real problem. Hey, how old are you? Or guess their age, or state your age for me. When did you graduate? That information is going to come to you in the form of gifts when you ask about whether the person has ever been trained in this area or what their educational experience is. You're going to get it anyway without asking it, but asking the question tells an applicant that you care about how old they are. And so when they don't get the job, you just exposed yourself to a claim even if it had nothing to do with their age. This candidate could be the worst qualified person on earth with zero skills in the field, surrounded by a whole pool of people who are very good. And so they're going to get disqualified anyway. You asked the question about age, you just opened the door, and it had nothing to do with the age, but guess what you just cooked up for yourself. Don't tell an older candidate that he or she's overqualified. Here's some real watch outs, and I used a couple of these a moment ago when we talked about our young, strong guys. Hey, we're a young, dynamic company. We're looking for fresh, energetic people. We need some fresh blood in here. This job requires a lot of stamina. Are you up to it? These are all code words for age discrimination. We know that, unfortunately, because these came right out of published cases here in Wisconsin and in the federal circuits around the country from age discrimination cases. These are the beginning steps in an age discrimination case. So it was employers who said these things, and then the applicant or the employee writing them down, remembering, she really focused on my age. She told me they're looking for fresh blood in there. And I'm sensitive about my own age because I'm old, and therefore I record that, I jot it down, and then guess what later? I get more comments about my age. Mark, how long are you planning on working? Are you thinking of retiring? I'm trying to do a budget for next year. How long are you going to do this? Very legitimate questions when you're constructing a budget. Very unlawful questions for an employer to say. So how can you get that same information? Are you a hardworking person, Lori? That's a very different question than, hey, we need some young, fresh blood in here. Are you up to the task, Lori? Especially if I'm looking at her differently. If I change my nonverbal body language at the point I ask about my need for young, fresh blood in the workplace, I'm sending a signal that I'm skeptical as to whether she's young, fresh blood or whether she's old, like me. All right, let's keep going. Don'ts. Marital status discrimination. A mother's maiden name, father's surname. Yeah, are you married? Are you divorced? Are you separated, single, widowed? Those things don't matter. We are looking for people to perform work. We're looking for how well they're qualified to perform the work. We do not much care their personal life and their personal status. And it should not be that we ask questions about that in the interest of trying to be social and friendly either. There are other ways to talk about that. We can talk about sports, we can talk about the evening, we can talk about the weekend weather, we can talk about a lot of things, and we'll have a conversation about that stuff without, in the interview, triggering it. Who resides with you? Doesn't matter. Getting into gender discrimination. Different questions that we would ask applicants based upon their gender. So if we ask the women different questions than we ask the men, particularly if this is a physically demanding job, we have a problem. So we need to ask all the questions of all the applicants without regard to any of these categories, and this one happens to impact gender more than any. Do you want children? So here's what we're telling the person. We're telling the person, hey, we're concerned about someone being gone for a period of time because we have a lot of work to do. How could I ask that question without asking the unlawful one? We got a bid out there on a project that's going to pop real soon, Lori, and we're expecting the work demand to go up dramatically. Do you have any vacations planned? Anything that you have planned that you know about that would make you unavailable for this project that we have coming up? I just asked the same type of question in a lawful fashion that will help me staff a job without asking her, hey, do you want children? You're pregnant? Are you going to have a child soon? All of those things are leading with our chin. And while our motives are pure, our verbiage is not. And so our goal here, because all these laws turn on an employer's motive and intent, our goal here is to have you all perform questions that show that you have a lawful and honest and good intent. Does your spouse or significant other work? That is asking the applicant to review their marital status and reveal perhaps gender, traditional divisions of labor with regard to a female applicant needing to be away from work at certain times for childcare reasons. And if we are concerned about the amount of work that someone's going to do, there's another way we can ask this in the same way. Do you have any obligations that will take you away from this project coming up? What's on the calendar, Lori? I'm interested in knowing as to whether you're available to work on this project. It's a big, heavy, and we can ask the same thing. I can get the same information. It's for a lawful purpose.
Okay, so just following up on that, because, you know, in this industry in particular, showing up on time for work in the morning is a big deal. I mean, tardiness is very difficult to tolerate just because of the way construction crews work. It's really important that people be there ready to work at the official start time, and I know that child care can sort of complicate that. So what's a lawful way to ask about the ability to be there at 7 o'clock every morning ready to work without getting into any kind of discriminatory area?
Okay, so the unlawful way to ask this would be, do you have any child care obligations that will prevent you from getting to work on time? Because I just shared with the candidate that I believe that women have a more difficult problem dealing with child care in the morning than men do. Especially if I only ask that candidate the question of the female candidates. So the lawful way to approach this is our industry and the type of work we do requires employees to be very prompt, particularly in the morning because of the type of work we do. And therefore, we have a strict work start rule, and we're looking at a shift start that will have the applicant, if you're hired, working from 6:30 to 7 as the beginning of the workday. Is there any reason that will be a problem for you? You know, do you live too far away? Are there things that would prevent you from getting to work at that time for you to be able to perform this job? Just because, frankly, I don't much care if it's two male applicants who happen to share a car or car share arrangement because they live close to each other that prevents them from getting to work because he's got to drop off his roommate. I don't much care if it's that or if it's a daycare one. Either way, I'm focused on getting work done at a certain time, and I ask about that topic rather than the underlying reason why. So the underlying reason why doesn't much matter. I don't care if Lori's absent from work because she's friendly to her neighbors more than she should be and giving them all rides, or it's child care. Bottom line, work is all that. Does that help?
Yeah, definitely. Thanks.
Okay. And I'm picking on Lori just because she's sitting in front of me, so I'll use her as the
and
continued
you know I
example.
have a tardiness problem.
So if she at any time dislikes this and you hear her throw something across the table, you'll know what that noise is. We're moving on with more don'ts here. We're in national origin discrimination, and then we'll move to religious discrimination. Whether the applicant is a citizen should not matter. Whether the applicant was born here or where he is from. So asking, hey, where are you from, Lori? Sends a signal that I doubt that she is like me from the United States. What kind of name is that? So if I focus on a person's last name or even their first name and question it, I might end up triggering a national origin discrimination claim. With regard to religion, hey, what church do you go to? Which synagogue do you go to? Who's your rabbi? Who's your priest? Who's your minister? Are you interested in religion? Do you believe in God? Religious faith, denomination. These are particularly dangerous areas in the era that we live in now. So there's been a heightened focus on Muslims as of late. The news contains more stories about Muslims as of late than it does about other religions. We have to be sensitive to this issue. This does not mean that we need to become some sort of political zealot where we are advancing a religion's interests over that of another religion. That's not what I'm telling you. What I'm saying is we should not care whether a person is Christian or Jewish or Muslim. We should care about work. And if a person shows up for an interview late, it doesn't much matter why. If a person shows up for an interview on time and they can't answer lawful questions about their work duties, that's all we should really care about. And so there's no real good reason for us to be asking whether a person's Muslim or Christian or Jewish or any other religious practice, because it doesn't lead us to the only thing we're supposed to care about, which is work. All right, continues, don'ts. What's your means for getting to work? Again, do I care if Lori comes in a car or on a bicycle or gets dropped off by a spouse? No, I care that she's at work at the time she's supposed to be at work. How about interest in unions, union beliefs, pro or against, fights with your union? Have you been someone who's a troublemaker for your union? Do you get along with the union business rep? All of those questions might help me understand what kind of personality the individual has, but we're asking them in a fashion that draws out the thing that we're not supposed to ask about in this context, which is their union beliefs. We are not entitled to know that. So I can ask instead, how have you handled disputes? Do you get in a lot of disputes? Tell me about your disputes. I'm focusing on the person's willingness to cooperate with other people and their track record of disputes. I'm not focusing on the why, which is union beliefs. Worker comp history, absences for illness. Hey, how sick are you? Do you have any medical problems, Lori? I mean, this is leading with my chin more than any others. Just don't ask questions that ask the applicant to share information about their race, ethnic, or gender stereotypes. So music preferences. Hey, what type of food do you like? Restaurants, bars, and clubs. Those things don't help me for purposes of determining what kind of worker she may be. So we're transitioning a bit into what you may ask. We'll do this for a number of slides. These are also things that you could use in your own practices. So elaborate on the, we want the person to elaborate a bit on their responses to the resume. So you've taken that lawful application process, you've obtained some information, and now you're asking them to elaborate on it. Think back to the slide with the open-ended questions. Lori, would you please explain for me what you wrote on your application about your work history at the XYZ company? Lori, would you please elaborate for me on what you did that was a success when you worked for the XYZ company? Why did you leave the XYZ company? Were you asked to leave, or did you leave on your own? Did you give them notice? I'm asking things about how she handled her employment relationship, not asking about any protected categories. And I am entitled to push her quite hard on those questions if I want. I could even say, I'm very concerned that you didn't give your employer any notice when you left there. Would you do that again? Because we don't want to be left in the middle of a job with you walking off. There's nothing unlawful about me asking questions that test her previous employment experiences. What kind of references did you write down? What were your prior job duties? Tell us about the skills you gained. Next slide, same topic. What kinds of job duties did you perform? Where did you last perform those duties? How long did you perform those duties? What did you like about your job? What did you dislike? And then how did you get along with supervisors? What was the management style that you liked the most? What was the one you liked the least? More questions. How would you handle a situation like this? So you could take an actual work situation, perhaps something that's happened recently at your business or a whole list of recent things. Think of the top 10 toughest situations that you faced in this particular job, or that the current work pool faces on a regular basis that you want this person to respond to. And then take those top 10 and say, if you were confronted with this, Lori, tell me what you'd do. And just test the person on the toughest parts of the job, the actual events that occurred. Most of these jobs are not jobs that you're making up brand new. We're not starting new companies here for the most part. And so you are already familiar with the work that's performed and people who are doing it successfully. Take the top 10 things that people have done in the past that are loser things to do on the job, the things that frustrate you the most on the job, and ask her those questions too. Somewhere in between there, we'll find out the applicants who are the great ones, and the rock stars, and then the losers. And we've asked them all in lawful fashion. Explain a time when you were faced with a situation. And now here's the cautionary note that I mentioned before, but it deserves repeating. We must ask these questions consistently of all applicants. So let's say I've come up with my top 10 toughest things in the workplace, and the best responses by employees, and the top 10 loser things to do in the workplace. And I'm pressing Lori hard on these issues. I grill her for 20 minutes. She leaves, she sits down, she waits on the process, we send her home, we're going to call her back. And a guy comes in, and I got 3 guys in a row scheduled, and I interview them from beginning to end, each of them 10 minutes, and I'm running out of time, and I'm looking at my watch, and I'm checking my calendar, and I'm realizing that I blew too much time in the beginning part of my day. And I just spent 40 minutes interviewing harshly the only female applicant, and all 3 of the guys got a pass. I had no bad intent whatsoever. I actually did mismanage my calendar terribly, and I just happened to look at the clock by the time the guys rolled in. But what have I done? I've set myself up for a gender discrimination claim because I grilled the female applicant and I let the guys get by with very few questions. And now I'm going to try and make some sort of objective decision based upon a whole pile of data that Lori gave me that the guys were never asked about. So just think about how you can construct each of these the same way, same questions, same time. If you get to 40 minutes and that's the time you set, Lori's done. Move to another applicant. Uniform, continued process that everyone has a chance to participate in without anyone having favoritism based upon a perceived protected category.
So toward that end, I mean, would you recommend developing a list of written questions that you ask every applicant the same questions in the same order, and never deviating from that list, or how much flexibility is there?
There's 2 approaches. The first is you could script it, and you could assure yourself that you've got a very clean process because every candidate got asked every question. There's some pros and cons to that. I'll mention that in a minute. The second option is you could have an outline that just contains topics, and you could allow the interviewer to have some space to decide what he or she wants to ask based upon where the conversation goes. The first approach, having it scripted, has the advantage of you don't have to worry about the person going off the grid and asking an unlawful question accidentally. And you're keeping someone on script. So this is the best approach for interviewers who frankly are green or have not done this much or have not listened to our training today, because you really only need to hand them a list and say, go ask this, and don't go off script. The problem with this approach is I lose a lot of opportunity to learn about an applicant based upon where the conversation goes. So our goal is to have interviewers who are trained and fluent and who've done this well. If we have those kind of people, or we aspire to have those kind of people, then we should think about over the course of time taking your greenhorn brand new interviewer and letting her or him grow from being confined by a script into the outline approach. So the outline approach would be, I've asked someone to construct a list of topics that are important for the job. Schedule, working with others, type of experience with these skills. And I've just wrote those high points on a sheet, and then I send Mark or Lori off into the room because I know that they can do this without asking, hey, we need some fresh blood in here, Lori. I know they're capable of doing that. You have to evaluate for yourself who you're going to have do this and how good they are, and you need to be honest with yourself. So if you're going to ask someone who happens to just be a very good, skilled tradesperson, and that's been their lifelong career, please don't expect that they're going to be very good at interviewing, because guess what they've spent 30 years doing? Not interviewing. And so evaluate who your people are and pick the amount of latitude you want them to have based upon their skill set, and be honest enough to confine them with the script if, quite frankly, they couldn't follow this without going off the reservation. Does that help?
Yeah, thank you.
Okay, legitimate reasons for rejection. And these are things that you can disqualify people for. I just wanted to highlight this so people were thinking about, well, what can I reject Lori's application for? Well, if she can't work the scheduled hours. Remember, I didn't focus on her child care issues. I didn't ask her that question because she's a woman. I just said, I'm looking for workers between 7 and 3. Can you work those hours? If the answer is no, she can't, I don't care whether the conflict is an auto conflict or whether it's a spouse conflict or a child conflict, I'm looking for people to work from 7 to 3. So she can't work those hours, I'm going to disqualify her. Now I better make sure that any guy who's unable to work those hours gets disqualified too, or I just set myself up for a gender claim. Hey Lori, do you have any experience with the volume of work that we're talking about here? We're very fast paced here. Do you have experience with that? No, I don't, Mark. I really never worked in an outfit that's moving this fast with this much work, or this kind of industry in this market. Okay. And then the next candidate comes in, and it happens to be a guy who's been doing this particular volume at perhaps a business that does even more than we do and been doing it for 10 years. I just found myself a lawful basis to disqualify Lori. Overqualified. Do you have to hire somebody who's got a PhD in a particular field to perform the very basic entry-level work? No, you don't. In fact, it's not going to be the right fit. And what's lawful about that? Do I think that there's a chance that this person will not be happy performing the entry-level job and be bored, and the morale is likely to be low because I'm frankly not even pushing any of their capabilities? Absolutely. And so overqualified is a basis, but it's also a trap for age discrimination. So be wary of saying to someone, wow, you've been doing this for a long time. Boy, you're an antique, Lori. I think you might be overqualified. Just get right to the point. Say, Lori, in the previous positions, you were the leader of the whole thing. How comfortable will you be starting out as the brand new person who reports to everybody and has nobody beneath you from a reporting structure standpoint? I'm asking her a question about how comfortable she'll be going from the top to the bottom of an organization. You're not sufficiently qualified. How about the personality? If the person is combative in an interview, it's lawful for me to say, Lori, you've been combative in the interview process. I don't think you'd be a fit for the team that we have. They're very collaborative in their workplace, and I don't think that the way you approach the interview would work and be successful in the workplace. That's lawful. Questions about her resume and her history, skills not as good as the preferred candidate, all those things are legitimate reasons for rejection. Here's some more. Unclear facts on her resume. So if she's been very vague, inconsistent references, references that are inconsistent with the facts given by the interview. So she says some things in response to interview questions that do not match up with the data on the application. That is a clue. Big gaps in her resume history. So if she didn't work for 20 years, do I dare ask the question whether it was because she was raising children? No. But can I say to her, I'm concerned that you don't have the experience in this industry like some of the other applicants, and use that as a basis for disqualifying her because she's not as qualified? I sure can. Her conduct during the interview, it's all fair game. If she shows up for the interview wearing flip-flops and Bermuda shorts, and all other applicants show up dressed like you would for the particular job, could even be jeans might be appropriate wear, but rolling in dressed like she's ready for the beach would be unusual. That's lawful. I can use that as a basis for disqualifying somebody. Or answers to key questions on experience and judgment. Again, the theme here, if you leave with nothing else today, the focus is we should be thinking about the work we perform. And if we stay on base with that and we have pure motives, I'm unlikely to step on a bear trap.
So, Mark, before we move on to the next slide, I think we have a question from the audience.
Oh, very good.
Going back to what we can ask about, one of our actors said, is it safe to inquire about questionable social media posts, for instance, a post attacking a former employer?
Oh, good question. I'm just going to repeat that because Simone's kind of far from the phone. I just want to make sure that it makes it to the phone. The question was, is it safe to ask about questionable social media posts? For example, if you've seen them post something attacking a former employer.
Yeah, that's a great question. I actually built into the slide deck the last 4 slides focus exclusively on social media.
Oh, okay.
As both a tool and a trap for employers, and we're approaching those quickly. So if it's okay, I would like to just address this question when we get to the content, because that's one of the hottest areas. It's very timely that the audience member asked that question, because there's no area, whether it's Facebook, whether it's someone searching a CCAP court case entry, whether it's just a straight up Google search, there's no area that's hotter when it comes to easy access of information about people than social media, and we're going to spend some time on that.
Okay, good question. We'll get there in a minute.
Okay, so this slide right here is a court example of an employer. Now this is an egregious example because there's 3,100 employment applicants, and we don't have that as a common occurrence. But it's just the point here is to draw your attention to. They ended up paying millions of dollars when they got this stuff wrong, and I threw this in there because it's a little bit of shock and awe. I do want people to pay attention. The amount of money we're talking about, if we screw this up, is not just in the 4 figures. This is 5 figures and 6 figure stuff, or even more in the case of large employers like this. All right, so we're talking about both state and local employment laws, and the purpose of this slide is to highlight that Wisconsin actually is one of the states that has a guide on fair hiring. One of our materials for distribution in connection with this is a copy of Wisconsin Fair Employment Law, Avoiding Discriminatory Interviewing Questions. And what Wisconsin did is they approached some of the same things that I highlighted in the early slides, whether it's age, date of birth, arrest, and conviction record. This is one other deliverable that you should think about putting in your folder to refresh your memory before you go in and perform interviewing duties. Most companies do not have full-time interviewers or recruiters. Most companies have people who are performing a number of functions. And so if you haven't done this in a while and you're going to do it again after a couple months off the job when it comes to interviewing, use this guide that Wisconsin has as a way to brush up.
And I think we've included that as one of the handouts for the webinar attendees. It's the ERD guide hiring PDF. So that should be in your webinar materials.
Okay, moving on to the next slide. What we've done here is I want everyone to think about this, and this is a slide that folks can keep in your folder. These are the protected classifications, and these change based upon state and certainly based upon municipality, but some of the main ones here include race, color, religion, gender, national origin, age, and disability. We talked about those already. Here's some ones that are not as intuitive because we don't hear about them as much. Genetic information, pregnancy, citizenship, military status, gender identity, sexual orientation, source of income and credit history in the case of the Madison Ordinance, and then arrest and conviction record under Wisconsin law. Keep those in mind because those are all the areas that we do not want to inquire about with regard to employment.
So let's say I'm a contractor who does a lot of work on schools, and I want to make sure I don't have any child molesters on my job site. How do I protect myself without discriminating under the law that prohibits that?
Yeah, it's a good question. I can tell you that yesterday I was at a training session at the Department of Justice in Madison, and they have individuals working in the crime lab and for the Criminal Information Bureau, and they said, Mark, are you telling me I have to hire felons in here to work on evidence for a homicide case at the crime lab? And the answer is no, you don't. And the same thing goes for questions that I've been asked over the years from daycare centers who want to hire someone to watch over a group of children. Schools are analogous to that. Wisconsin law provides the following. It provides that it's illegal to discriminate against individuals on the basis of their arrest record and their conviction record, unless the conditions of the job substantially relate, and those are the magic words, substantially relate to a person's conviction.
Okay.
And it's based on the conviction statute. So if a person has been convicted of sexual assault of a child, and the particular employment position would substantially relate such that we're creating an environment where the person would repeat the behavior, we do not have to hire them. So if someone has a background that includes theft convictions, a bank does not have to hire the person to work the till, the money. If a person has a background of burglary convictions, a security company doesn't have to hire the person to work night shift, single, no supervision security job. If a person has domestic battery charges in a spousal relationship or girlfriend-boyfriend relationship, a women's shelter does not have to hire the person to work the desk at the women's shelter. If a person has drug convictions, a pharmacy does not have to. So I think I'm trying to draw some of the common cases here. Bottom line is, if you have a project that's in a school, you do not have to put people in there who have engaged in crimes against children. Could be sexual assault, could be battery of children, could be kidnapping, it could be sales of drugs to children. It could be anything that involves children, and if that job involves children, you don't have to do that. There are areas around the edges that are more difficult, but those are the basic rules. Does that help?
Yeah, it does, and that leads to a follow-up question, though, because our trades require, as part of our collective bargaining agreement, that in order to be eligible to work, you have to pass a drug test. How does that interact with the arrest and conviction history? I mean, if somebody has a conviction for a drug crime, how does that interact?
Yeah, so the only interaction between the two would be is if you only asked convicted drug offenders of participating in the drug program.
Okay.
Because then you're picking on them because of their conviction.
Okay.
If the drug testing provisions apply to everyone, convicts and individuals who have not been convicted, then there's absolutely nothing about, there's no relationship between the drug testing and the conviction of the arrest and conviction record.
Great.
Same thing with people who've got OWI on the record.
Okay.
If you only asked them to participate in a sobriety drug testing system, we'd have a problem. But if you do it for everyone, and they just happen to be part of the pool, no problem at all.
Okay.
Okay. Good questions. Background and credit checks. I've got 4 slides on this. We're not going to spend a lot of time on this because it's a nuanced area, but there could be positions that require you to be interested in credit checks. You could have bookkeeper or other positions that come along the way. This is not the bulk of the jobs that I understand we're going to be looking at here because of the changes in the hiring procedures that have occurred. But I wanted this in there so that when you go back and you brush up 3 or 4 years from now and you're hiring someone for the office, you'd be thinking about this issue. For background and credit checks, the EEOC has recently taken the position that those criminal records and those poor credit histories adversely affect Hispanics and African Americans because of some societal issues, and therefore be thinking about how you use the issue of background checks and whether it's targeting a portion of your applicants more than other portions. In other words, are you screening out applicants on the basis of credit history when, for starters, credit history is not that important for the type of work that you're hiring for? And also, are you picking on a particular protected category doing that? Zoom out from what you're doing and ask why. Go back and look at how you've hired people and ask whether your background check process, if you have one, has been lawful. And don't trust that it's lawful just because some third-party vendor is doing it for you. I have a number of clients who use third-party vendors for background checks, FMLA administration, disability law administration. I can tell you that as a general rule, the third-party companies doing that break the law all the time. And guess whose rear end is on the line when an employment law is broken? Not the third-party vendor, the employer. And they get to wash their hands and walk on off into the sunset after you fire them for breaking the law, but who's holding the tab from that employee claim? So be thinking about this with your background checks. Credit checks. Any credit check that you perform is subject to a law. It's a federal law known as the Fair Credit Reporting Act. Bad news is it's not known very well, and most employers will break it if they don't pay attention to it. The good news is, like FMLA, it's very formulaic. So it's not like these discrimination laws, which means that a bookkeeper, office person, HR person can learn the process and repeat it every time, and you'll be compliant. On the next 2 slides are some of those compliance steps, If you have credit checks that are performed, make sure that you designate a single person to look at these steps on these 2 slides and ask whether you're giving the adequate notice, authorization, certification, and information forms. These are just forms, and it's as simple as handing the forms to the person and making sure that you disclose the information. You can use the information in the consumer report to make your employment decisions, but you can only use the information if you give the adequate notices and forms. So I wanted this in there more as a hey, heads up than anything. Now we're into social media. And so this is the last chapter of our training. This is also the most relevant. It's the one that we can finish with. They'll have the most punch. So let's walk through this, and we'll try and answer that question about what if we learn about an applicant who has badmouthed another employer, and they've done it by blasting the employer on Facebook or who knows where. So we'll start with this slide. This is a gift. I got to tell you that the number of employers who are able to find out information on your very nice appearing and very impressive applicant on paper and an interview form, the wealth of information that's available is just a gold mine, because people live in this era where they seem to broadcast all of the inappropriate behavior that those of us who are old have the privilege of having it buried decades ago. And guess what? We didn't have them. We didn't have cell phones. We didn't have cameras on everything that we carried. And these days, more than ever, there's a generation of people who just broadcast all kinds of bad behavior, and they do that without any recognition that it really does live on and it can impact them. And there are many employers now who use social media and internet sites and Google searches to vet and screen applicants. And many don't do it because they're concerned with what they might find, but there is a wealth of information out there. So the good news is the largest compilation of information is available at the internet, and you can verify statements that are made in applications. I have a lot of clients who do this. You can learn more about the employers that they cite on their applications. You can go look up a web page for the type of business that it is. You can test whether that business really does what Lori told me that they do. I have immediate contact information to reach out for. I can look and see whether the person that she listed as the contact person is there anymore. It's really easy and it's helpful for you. I can also learn about her background generally instead of just being tied to a resume. I could Google her name and see what organizations she's been involved with, whether she's done any public speaking. I can find out if she's affiliated with any entities today, and that's helpful. I can also discover personal details about her, and this might call her judgment into question. For example, her use of discriminatory language in social media. So let's say I'm interested in learning about Lori, and I type in her name as a Google search. I find a treasure trove of information. Have I done anything wrong yet? Not on that fact pattern. Let me change the facts with one more piece. I didn't search for the male applicants. So that one fact changes. Now what I've done is I've created an environment where I'm only scrutinizing my female applicant. That's a problem. So like any of those other questions or rules or steps, this one must be uniform and across the board. So now I've Googled her and I've Googled my male applicants too, and so I'm applying the process uniformly, and along I find some posts where she has used discriminatory language. We'll use in this example racial language. It could be religious hostility towards a particular protected category, and she's done that in social media, not in a job. She's doing it apparently in her private time, in a forum, with people who are on there who are social acquaintances, and as far as I can tell, there's absolutely nothing connected with any prior job, and she's sitting here today to be interviewed, or I already interviewed her, and what can I do with the information that she posted where she's blasted some other person or group based upon protected categories? Can I disqualify her from employment based on those grounds alone? The answer is yes. I do not have to tolerate someone in my workplace who's going to have a belief system that's inconsistent with the law. I am not interested, and nor am I required to expose myself to a legal claim because I hired someone. In fact, by hiring her, arguably, I'm on notice that she's likely to pick on other people in the workplace based upon their race, religion, age, disability, etc., because she has a history of doing it already. So here's the next bullet on the slide, which is the exact issue that was asked in our question, which is negative commentary on a former employer or other organization in social media. I can discover that. Can I use that? Yes. If she posts how much of a jerk her former boss is, and she blasts him or her in social media, she's already told me how she handles disagreements or problems in the workplace. I do not have to accept that applicant based upon how she handles employment issues. It's no different than the question I asked her, which was, tell me how you resolve disputes in the workplace. Have you had disagreements with the supervisor before? Apparently, she handles those things publicly. Now, there is a body of law that addresses workplace disputes that are concerted. We're probably all familiar with what unions can do when they don't like something that happens. So if Lori is engaging in protected and concerted activity online about her former employer or current employer, and it's concerted activity, meaning she's taking up the cause because her employer is cheap and won't pay, that's no different than a picket sign out front. On that set of facts, I can't use that. But if what she's doing is just calling someone a jackass because the guy and her, the two families have known each other since high school and they've always hated each other, it's personal, it's not concerted, it's not that, hey, she's standing up in charge of a group of people who are fighting for an increase in wages of the sort that we would all believe in our mind to be similar to what we know unions can do. So think of what we know unions can do and ask yourself, is Lori doing that online or is she doing something else? If it's something else, I can use that as a basis against her. Other posts. How about posts that demonstrate a serious lapse in judgment or serious lapses in judgment? So how about a post that shows a picture of her at a bachelorette party with a pitcher of beer in one hand while she's cranking down the interstate at 70 miles an hour, and you know, the ladies are whooping it up? Do I have to take an applicant who expresses that kind of judgment, particularly if it's posted online? No, I don't. That tells me about her decision making. And I'm not interested in her either using my vehicles or engaging in behavior with that kind of judgment in the workplace. So before we move on from that, did we address the question? I think we addressed the question, but...
I think so.
Okay. So we're still in social media. We're still continuing on learning of a protected characteristic. So let's say I learn, based on a Google search, that Lori suffers from a disability. Let's say I learn that a Google search turns up that she's part of a diabetes forum and that she engages in fundraising on behalf of a local diabetes organization. She suffers from diabetes and has a family member that does as well. This is part of their life to develop more funds and research, etc., for fighting and controlling diabetes. And there's even a post in there where a little audio clip based on some sort of a marathon or a walk for diabetes, and then she's on the news talking about the amount of money they raised, and she's so proud to be someone who is in this position, etc. So there's clearly nothing that I can do to erase from my mind that I now know Lori is someone who suffers from diabetes. Well, I have information that I wouldn't normally ask for, but it fell in my lap. So one of the risks of engaging in social media checks is I may end up with information that I cannot unknow. The same could be true of religion or sexual orientation. If I have that kind of information, and I did not go looking for it, my obligation is to make sure that any decision I make is completely divorced from that information, and then I have to recognize, though, that I am standing in a slightly heightened position of risk than I would be if I got to say later, I had no clue she's disabled or in any capacity. In fact, the first time I heard about her diabetes was when I saw the equal rights discrimination charge roll in. That's one of the best defenses in the world, because guess what I couldn't have used as an unlawful basis? I didn't know about it. If you become aware of it, and it's through this type of a search, you just can't unknow it, and you just have to make sure that your process is as clean as possible. So what should you do with that information upon learning? Well, first off, I shouldn't be writing in the file, Google search, champion of all diabetes fundraising activities in Wisconsin. There's absolutely no good reason to write down that Lori follows through on those type of convictions or beliefs, because the only reason I'd be writing it down in an application or employment file would be to use it later. I shouldn't be emailing people at work or other interviewers about that information. I shouldn't be sharing it verbally with people at work. There's no reason for those people to know that piece of information, because I don't want to cloud their mind with a piece of data that I found out about accidentally. All right, some long-term and immediate consequences here. Knowledge. That's great evidence for an applicant who turns litigant, and knowledge of disability may saddle us with responsibilities under the ADA. I pretty well just spoke to that, which is we just can't unknow those things. So think about this before you engage in these searches, because you may end up with information that you really didn't care to know, and you can't unknow it. Learning a personal detail that causes discomfort or is otherwise stigmatized but may not be considered. So in Wisconsin, we may not discriminate against people on the basis of using products that are lawful. And so we may not discriminate against people who smoke. That does not mean we need to tolerate smoking in certain areas of work or even building, etc. But we are not allowed to discriminate against people on the basis of the use of lawful products, and that's a lawful product. We may not discriminate against Lori because she happens to be someone who owns firearms. That's a lawful activity, and that does not mean, however, that we have to allow her to use them at work or even have them on our property. We have the right to control the workplace. Or drinking. We are not allowed to discriminate against people because using alcohol is lawful for people who are of legal age, and this is different than the example for blasting down the interstate earlier with a pitcher of beer in her hand, because that clearly is not lawful behavior. All right, can an employer legally decide not to hire a candidate based upon the review of social media? And this is kind of where the rubber hits the road with this. The answer is yes, so long as that employer does not violate state or federal discrimination laws. And there is absolutely no prohibition against using information that you learn in the public domain. So if it's unrelated to disability, it's unrelated to race, gender, national origin, age, pregnancy, conviction record, if it's unrelated to those things, we can use it. If it's related to those things, we cannot use it, because it would be just as unlawful as we said to Lori. Tell me what disabilities you have. Tell me your sexual orientation. How old are you? All of those questions would be problematic, so we should not be seeking that information when we search an applicant online. Same thing with the CCAP. Wisconsin has a very helpful court access page. It does not access federal court information, but it accesses state court information. And many, many employers go looking there. The problem is that you should be thinking about what you find out there before you ever go looking. Because if you don't have a substantial relationship, which was the test that we mentioned earlier, you may actually find yourself really not wanting to hire someone who's got a dozen convictions for battery and disorderly conduct and a bar fight and all kinds of conduct that gives rise to some reason to doubt her character. But if it doesn't substantially relate to the job, you will not be able to lawfully use it. And once you look at it, you will be stuck knowing about it. And what happens with CCAP more than any other area is people talk about it at the workplace. So they search a candidate based on CCAP, and they find out there's a dozen restraining orders against the person based on a relationship. Like, oh my gosh, this guy's been hauled in and out of court by every person he dated over the last decade. This must be a jerk. We don't want a guy like that here. It's lawful to discriminate against people because they're jerks. It is not lawful to discriminate against people based on their conviction records unless it substantially relates. So if we're hiring someone to work alone in a warehouse as a janitor on a night shift, we will not be in a position to use their restraining orders in domestic relationships because it's not going to be substantially related to the position. So we should not go looking for it, which means that different jobs require different application and hiring processes. The questions that you ask an applicant for a skilled tradesperson is a different set of questions that you ask an applicant to be a bookkeeper, or to be an accountant, or to be in sales, or to be in security, or to be a janitor. and you shouldn't go with one size fits all. So your interviewer should plan a process that's designed around, what do we start this day with? Work. What's the job we're trying to fill? What information will help us find out if the person's the best fit for the job? And then we ask questions that relate to the job. And we Google search or we CCAP search only if we've already decided that we're comfortable learning about a bunch of bad information, because it's going to substantially relate. So if I want to hire a bookkeeper or an accountant, I absolutely will be conducting a background check. I want to know if there's any financial crimes on it, because if I learn one, I'm not going to hire the applicant because I don't need to under Wisconsin law. That same search, though, for someone who's just going to perform an entry-level apprentice-type job is probably going to tell me more bad things than good things, and then I may have some legal risk. All of these things are business decisions. So my final point to you is there is no such thing as the risk-free employment decision in the world. It doesn't exist. There are different degrees of risk. So anything from low risk to very high risk. And only you can decide how much risk you want. And with more information comes more risk. Somewhere in between very low risk and very high risk is the happy medium that most employers opt for, because they still have to run a business, and sometimes drawing the claim, if your motives are pure and you're doing it for the right reason, is part of doing business and a business expense that they're willing to take. It's not possible to make good decisions if you ask 0 questions. You want the risk-free employment hiring process? Take everyone who walks in the door, ask them no questions. The most risky, tell me your age, what's your religion, how old are you, do you have a spouse, etc., etc. That's the other end of the spectrum. Somewhere in between there is the right temperature for all of you, and only you can decide that. But my goal is to provide you with the tools to make very informed business decisions about how you hire people, not to tell you how to do it, but to tell you some best practices. And the slide deck that we have just completed today has a number of best practices that we ask you to put in a folder so that you can refresh your memory on these topics when you're about ready to go prime time and engage in some interviewing. And with that, I think we've covered the slide deck that we made for today, Lori. Any questions that came up and submitted?
Nope. Yeah, let's just give the folks on the line just another minute or two in case there are any follow-up questions they want to submit. But otherwise, I'd like to thank everybody for their time today and thank our presenter again, Mark. This was a great informative presentation, and I really think it will equip our attendees with the tools to conduct effective and lawful hiring interviews.
It's all my pleasure. I appreciate the opportunity to get together. This is much more fun than dealing with litigation, and hopefully this is a type of preventative maintenance that gives folks a chance to avoid claims. The goal here is definitely not to put my kids through college because I'm defending lawsuits, but to help people so that they can avoid the need to use lawyers in a litigation context. And if anyone has questions, follow-up that they think of later that they want to ask or email, I'm more than happy to engage in a discussion at a later time.
And Mark has included his contact information, I believe, on the front slide, or maybe not. If you do have follow-up questions, feel free to reach out to me, and then I can either engage with Mark or find the best way to get an answer to your question. So with that, we're going to end today's webinar. Thank you, everybody, for attending, and look forward to future presentations of this nature.
Thank you.
All right, thanks, everybody. Take care.